Hello there. Can everybody hear me? Oh, don't let me touch anything. It's going to start getting loud in here. Oh, thank you so much, Soup. Thank you, thank you, thank you. You ended your live for this? You did not have to do that. You guys could have caught it after. Oh, I'm sorry about that, Soup. So I do. Soupy Doopy sent us. Not the Soupy Doopy. I do have the documents, so we are going to read them out. They're here just so that you guys know that I'm not crazy, that we do have them. So we're just going to start reading them. Shut your whole face. Soup made us come. Thank you, Soup. Okay, so we know that, or everybody heard last night in that interview, that Seth Rogers has filed suit against the Tennessee Department of Children's Services as well as Sumner County. So we're going to go over exactly what he's filed and exactly what he's looking for. Am I very quiet? No. I feel like I'm super crazy loud. Let me pull it even closer. How's that? Is that better? Let's see. Cammy said very too. It's just fuck with me to fuck with me, right? All right. Hold on. Children of the corn here. All right. And I'll adjust it a little bit too for you. Adjust your mic volume to 106%. Sounds good. Listen. All right, we're going to give it 15 seconds. Everybody type in the chat too low or too high or just right. Great. Good. Wonderful. Perfect now. Great. I have a loose wire, which is why this happens, but all right. Now we're ready. This civil rights action arises from the Tennessee Department of Children's Services, DCS, failure to protect minor child, which we know that right here, Sebastian Wayne Drake Rogers is the child he's talking about. 15-year-old child with autism spectrum disorder, severe combined type ADHD, and 6q27 chromosome deletion syndrome, who vanished from his mother and stepfather's home in Hendersonville, Tennessee on February 26, 2024. Sebastian is not an ordinary missing child. He is profoundly vulnerable minor with multiple documented disabilities, a history of sexual abuse that has been reported to and investigated by the Tennessee DCS, and a home life that DCS own records show was marked by physical abuse, emotional degradation, yes, and a stepfather whose neighbors reported, quote, hated the child and wanted the child to die. DCS has formally determined that Sebastian was, quote, at risk or imminent risk of removal from their home. Now, let's just pause for a second and say everything in here is an allegation. It is not proof of anything. We don't know. Okay? Be just careful with your remarks in the chat, but this is what's out there. This is public, and, the mods will handle the chat, but, you know, these are parents of the missing child. So just be careful, okay? I don't know, Jen, if there are. I don't think that they would put those in here, but if I feel like I'm coming up to one, I will um, private and check. But here we go. DCS investigated Sebastian's household on two separate occasions based on allegations of sexual and physical abuse. On both occasions, DCS closed its findings, quote, no concerns, and, quote, no services needed, despite documenting alarming evidence that Sebastian was living in a dangerous and abusive environment. Approximately 9 months after DCS closed its second case, concluding no services needed, Sebastian disappeared. Okay, so now we know that the case was 9 months prior to him disappearing, was the last one. He has never been found. DCS own records establish that it knew this child was in danger, documented that danger in meticulous detail, formally determined he was at imminent risk of removal, and then did nothing. This inaction constitutes deliberate indifference to Sebastian's constitutional rights and directly contributed to the circumstances of his disappearance. This court has subject matter jurisdiction pursuant to 28 U.S.C. 1331 and 1343. Supplemental jurisdiction over state law claims exists, 28 U.S.C. 1367. The venue is proper in this district pursuant to 28 U.S.C. 1391b because this district is the judicial district in which a substantial part of the events or omissions given rise to the claims occurred. Just making sure and make sure that my audio is proper. Okay. Parties: plaintiff Seth Rogers, who is Sebastian's biological father. He resides in Clarksville, Tennessee. He brings this action individually and as the father and next friend of Sebastian. Defendant is the Tennessee Department of Children's Services. This is the agency of the state of Tennessee, established pursuant to Tennessee Code 37 5 101, and it is responsible for administering child welfare services throughout the state, including the investigation of reports of child abuse and neglect, the placement and supervision of children in foster care, and the provisions of services to children and families. DCS maintains its principal office at 505 Dedrick Street in Nashville, 37243, and operates through regional offices and caseworkers across the state of Tennessee. At all times relevant to this action, DCS acted under color of state law and through its agents, employees, and representatives who were acting within the scope of their employment and authority. Defendant Margie Quinn is the commissioner of the Tennessee Department of Children's Services. She is sued in her official capacity for prospective, injunctive, and in her individual capacity for damages to the extent she personally participated in establishing or maintaining the policies, customs, and practices that caused the constitutional violations alleged herein. All right, let me just fix my microphone here. Whoops. Okay, sorry. Yeah, they must have gotten access, of course. Yeah. Give me 1 second here. You know what I'm saying? One second. All right. This damn microphone, man. All right. Defendant Leslie Keeley Ritchie was at all relevant times a team leader at DCS, Mid Cumberland Region. Ritchie conducted the administrative review on the physical abuse case ID, and they give that, and the closed case as no services needed. She also participated in the 2022 sexual abuse investigation case ID, which provided her with actual knowledge of Sebastian's history and vulnerabilities. She is sued in her individual capacity. Defendant Laura Boswell was at all relevant times a case manager at DCS Mid Cumberland Region. Boswell conducted the face to face interviews with Sebastian, the Proudfoot family, and Seth Rogers on both the 2022 sexual abuse investigation and the 2023 physical abuse investigation. She personally documented Sebastian's disclosures of fear, abuse, and trauma. In the 2023 physical abuse investigation, she failed to interview Rogers as Sebastian's other legal parent with joint physical and legal custody and participated in the decision to close the case as no services needed without protective action. She is sued individually in her capacity. Defendant Amira J. Walker was at all relevant times a supervisor at DCS Mid Cumberland Region. Walker approved the closure of this case as administrative closure on November 15th, 2022. She is sued in her individual capacity. Defendant Does 1 through 15 are DCS employees, supervisors, and officials whose identities are presently unknown, but who participated in the investigation, supervision, and closure of the DCS case involving Sebastian and or who established, maintained, or ratified the policies and practices that led to the constitutional violations alleged herein. Plaintiffs will amend this complaint to identify those defendants when their identities are ascertained. Okay, here we go with this. Factual allegations. Sebastian's history of abuse and vulnerability were known to DCS. Sebastian was born to Seth and Katie Proudfoot. His parents are separated, and Katie married Chris Proudfoot. Sebastian lived primarily with his mother and stepfather. He was diagnosed with autism spectrum disorder, severe combined type ADHD, and 6q27 chromosome deletion syndrome. He had an individualized education plan, an IEP, and a Section 504 plan requiring his school to provide him with accommodations because he was a student with disabilities. Sebastian was in the behavioral program at his school, received therapy 3 times per week through the mental health cooperative, was on Concerta, saw a neurologist at Vanderbilt, and was scheduled to begin his ABA therapy at the time of his disappearance. His therapist reported that as a consequence of prior sexual abuse, his therapist reported that as a consequence of prior sexual abuse, Sebastian was sexually aggressive and suffered from frequent bathroom accidents. Law enforcement reported that Sebastian had some homicidal thoughts. Sebastian's multiple disabilities made him uniquely vulnerable to abuse, neglect, and exploitation, and required DCS to exercise heightened care to provide reasonable accommodations under the ADA when assessing his safety and needs. On or about September 28th, 2022, at approximately 6:33 p.m., a call was placed to DCS Child Abuse Hotline. The intake was screened as a priority 3 with allegations of sexual abuse against an unknown perpetrator. The alleged child victim was Sebastian. The intake reported that on September 28th, 2022, Sebastian disclosed to a school professional that 2 years earlier, while living in California with his mother, he experienced sexual abuse by another child, Child B. Specifically, Sebastian disclosed that Child B would make Sebastian put his mouth on Child B's private area. and both he and the child would put their private areas in each other's butts. Sebastian said he was forced to do this by child B, and that it occurred in the upstairs of his home in California and happened several times. Sebastian reported that child B was his only friend, and that child B threatened that if Sebastian didn't perform these acts or if he told anyone, they would no longer be friends. Sebastian reported the abuse occurred when he was 10 or 12 and it happened several times over weeks. Sebastian told the school professional that after he told her, she was the only adult who knew besides my mom. The intake further documented that Sebastian stated he was disgusted with himself about what happened and that it had gotten much more difficult to pretend like it didn't happen. The intake noted that Sebastian struggled with behaviors after he moved to the Sumner County District School and was placed in the behavior program at Schaefer Middle School. Critically, the intake documented that Sebastian stated that he is afraid of what his stepfather, Mr. Chris, would do if he found out, and that he is afraid he will get hurt for telling an adult what happened. The intake further noted that stepfather has used corporal punishment on Sebastian several times before, and it is unknown if he knows about the abuse or how he will react or blame Sebastian. The intake also noted that Sebastian suffered from frequent bathroom accidents and displayed some verbally sexually aggressive behavior towards multiple other students. On September 29th, 2022, Ritchie conducted an administrative review. She documented the sexual abuse allegations and noted the next steps would include a full assessment. Initial face-to-face response was due by October 3rd of 2022. On September 30th, Boswell met with Sebastian at Schaefer Middle School in a private conference room. Sebastian told Boswell he feels safe with his family at home and that he feels safe at his dad's home. Sebastian identified his father as Seth Rogers, who lived in Clarksville. Sebastian stated something happened when he lived in California, but he did not want to talk about it at school. Boswell noted Sebastian had no visible marks or bruises, appeared happy and healthy at this time. On October 12th, Boswell mailed a certified letter to the family, noting they had recently moved and there was no forwarding address. On October 17th, Ritchie conducted another administrative review and updated the case, noting that Boswell had seen the child and he did not want to talk about what happened in California, that the family was moving, and that efforts to contact them had been unsuccessful. That's very strange. Yeah, it does stink that any of us know this now, so it just. On October 27th, 2022, Boswell conducted a home visit. Katie stated she does not understand why this keeps getting called into DCS and that the abuse happened when Sebastian was 8 and another child named Jonathan was involved. She stated that CPS and detectives were involved in El Cajon City, El Cajon, I'm not sure, in California. She provided the California address of that. She confirmed that severe combined type ADHD, 6q27 chromosome deletion, took Concerta, had an IEP behavioral plan, and was starting therapy with Vanderbilt Psychiatry on November 3rd. She confirmed that Sebastian also saw a neurologist at Vanderbilt. During the same visit, Boswell spoke to Proudfoot in private. Proudfoot stated this was all investigated in California, that he had never spanked Sebastian, so he does not know why Sebastian feels he would be mad for talking about what happened in California. This statement was directly contradicted by Sebastian's own disclosure that he was afraid of what his stepfather would do, and by the intake noting the stepfather had used corporal punishment on Sebastian several times before. DCS did not reconcile this contradiction. Boswell then met with Sebastian in private, noting he was completing his homework and appeared happy and healthy. On November 1st, 2022, Boswell verified that the sexual abuse case in California had been investigated by Detective Gloria Mendoza and El Cajon. I don't know. She also verified mental health services and Vanderbilt appointments for Sebastian. On November 3rd, the case was presented to the Sumner County Child Protective Investigative Team, which included Juvenile Court, Ashley's Place Child Advocacy Center, Assistant District Attorney Jenny Smith, and law enforcement. A detective was assigned to the case. All members agreed to classify the case as administrative closure. On November 7th, 2022, Ritchie updated her review, noting the case has now been presented to CPIT as administrative closure as it was investigated in California. This was child on child, and they were the same age. The child reports no concerns at this time. The child is getting back into therapy services. The child reports no concerns. The mother is protective and proactive with the child. On November 14th, Ritchie spoke to CAC Director Amy Salyers, and the classification was changed to unable to complete based on policy 14.7 because the incident occurred out of state. On November 15th, 2022, Supervisor Walker completed the final administrative review, approved the case for closure as unable to complete due to the incident occurring out of state, and the case was closed. The foregoing investigation gave DCS and law enforcement actual knowledge of Sebastian's vulnerability. By reason of this actual knowledge, DCS and law enforcement were on heightened notice that any subsequent allegations of abuse by Proudfoot or within Proudfoot household required a more searching and skeptical investigation than they would otherwise apply. The first investigation's findings were not a clean slate. They were a documented predicate of danger that obligated DCS to treat any future report concerning this child in this household with the gravity the circumstances demanded. Whew, okay. Okay. Here we go. This is going to be the physical abuse one. So, again, take care of your mental health. If there's anything in here triggering to you, you should, hop out or do whatever it is that you need to do to, keep your own mind safe here. Give me 1 second here. I don't want to keep holding this fucking microphone. I apologize. It's pretty triggering. This is not an easy read here at all. I wasn't quite sure what was going to be, put in here, but here we are, right? A lot of people, they're making it up. These things didn't happen. I always thought that they did happen. I didn't think we would get here, though, but here we are. All right. Next. On May 3rd, 2023, at approximately 9:06, a second call was placed to the DCS Child Abuse Hotline. This intake was screened as a priority 3, with allegations of physical abuse against Proudfoot. The alleged child victim was Sebastian. The intake reported that Proudfoot had made comments about pushing the child against a wall when he does not behave, and that the child reported Proudfoot hit Sebastian in the belly. On May 8th, 2023, at approximately 6:30 p.m., Boswell arrived at the family home. Proudfoot granted permission to enter. Boswell met with Sebastian on the porch. Sebastian stated he remembered Boswell coming to his home last year. During the interview, Sebastian told Boswell that Proudfoot required he wore a belt every day. Sebastian stated that Proudfoot asked him to lift his shirt, and when Sebastian did, he did not have his belt on. Proudfoot smacked him in the belly with the back of his hand and said, "You know you're supposed to wear a belt." Sebastian also told Boswell that he had been lying to Katie and Chris about brushing his teeth and making his bed, and that he had been getting in trouble for lying. Boswell then met with Proudfoot on the porch. Proudfoot admitted he was cleaning Sebastian's drawers asked Sebastian if he had a belt on, and when Sebastian pulled up his shirt and said no, Proudfoot whacked him in the back. No, pause. Proudfoot whacked him with the back of his hand in the belly and said, "Boy, you know you're supposed to wear a belt every day." Proudfoot stated that Sebastian had to wear a belt because he needed to start wearing pull ups. Proudfoot claimed he had never physically harmed Sebastian. Proudfoot's own admission is that he whacked a child with a diagnosis of autism and multiple disabilities in the belly, and that constitutes physical abuse. His requirement that Sebastian wear a pull up and submit to shirt lifting inspections constituted degrading and humiliated treatment of a disabled child who suffered from documented bathroom accidents as a consequence of prior sexual trauma. God, this is absolutely heartbreaking. Boswell spoke to Katie in the kitchen. Katie said they've been working with Sebastian on when he tells something to tell the entire story, and that Sebastian will tell bits and pieces of the story to fit a narrative. She stated she had no concerns that Mr. Proudfoot smacked Sebastian's belly with the intent to hurt him. On May 9th, 2023, Boswell verified Sebastian was receiving therapy services 3 times per week through a private therapist and medication management through mental health cooperatives. On May 11th, Ritchie conducted the administrative review and concluded this case is ready for closure at this time, no service needed. Case manager has met the family and they denied any concerns. The child reported being safe in the home. He stated the stepfather popped his belly and told him to wear a belt. The child denied any physical abuse in the home. The stepfather reported the same as the child. Ritchie noted the fast is completed with no need for intervention. On May 11th, 2023, the case was closed as no service needed. DCS failure to conduct a minimally adequate investigation was compounded by its complete failure to involve Rogers, Sebastian's biological father, who held joint physical and legal custody of Sebastian pursuant to a court order. Despite this, DCS never notified Rogers that the investigation was underway, never interviewed him as Sebastian's other legal parent to obtain his observations regarding Proudfoot or the conditions in the Proudfoot home, never offered to place Sebastian with him during the investigation, notwithstanding that such placement was clearly within DCS authority and was the most obvious protective measure available. Had DCS fulfilled this most basic obligation, it would have learned critical information that was never captured in the case file. Rogers would have told DCS investigators that Sebastian has expressed to him on multiple occasions that he was more comfortable with Rogers than with Chris, and that Sebastian was afraid of Chris because he believed Chris would hurt him if he disclosed what had been happening. Rogers would have informed DCS that Chris has ridiculed Sebastian about the prior sexual assault, compounding Sebastian's existing trauma and making Sebastian even less likely to disclose abuse to any adult he believed would report back to the Proudfoot household. Rogers would further have told DCS that Katie had spoken to him on multiple occasions in terms that evidenced her frustration with the hostility towards Sebastian, telling Rogers repeatedly how fed up she was with Sebastian for the ongoing incidents of soiling and wetting himself, the very same bathroom accidents that Sebastian's therapist had documented as a known consequence of his prior sexual trauma. Rogers would have advised DCS that Sebastian's mental state had been deteriorating, that his behavioral problems were worsening, and that Sebastian himself appeared increasingly distressed in the period leading up to the investigations. DCS already possessed documentation of Sebastian's escalating behavioral issues. A minimally competent investigator would have recognized Sebastian's worsening condition not as a fixed background fact, but as a contemporaneous warning sign that something in Sebastian's living environment was causing him active harm. DCS did not investigate the cause of Sebastian's deterioration. It closed the case instead. Pause. Okay. Let me take a sip of my soda here. This is a lot. This is a lot. Yes, he was twisting, allegedly. Thank you, Grandma Sherry. Thank you so much for that. All right. All right. Sebastian's disappearance. On February 26, 2024, Katie reported that Sebastian left the home on his own. Whereabouts are unknown, and Sebastian has never left the home before alone. Given Sebastian's neurodivergence, his developmental disabilities, and the documented history of abuse in the home, this report should have triggered the most intensive investigative response possible. More than 48 hours after Sebastian was reported missing by his mother, an Amber Alert was issued by the TBI. The Sumner County Sheriff's Office initiated a search that at the beginning involved significant resources, including community volunteers and search teams. A DCF safety assessment was initiated on March 1st, 2024, and a FAST 2.0 assessment was completed on March 5th. As of the date of this complaint, Sebastian has been missing for nearly 2 years. He has not been found. No arrests have been made. The circumstances of his disappearance remain unknown. Rogers has been left in a state of unrelenting anguish, and I think this should say nearly 3 years. Correct? I believe so, but could be a typo. Rogers has been left in a state of unrelenting anguish, not knowing whether his son is alive or dead, and knowing that the state agencies entrusted with his son's protection failed him at every turn. DCS own records from the 2022 sexual abuse investigation are critical context for understanding what DCS knew when the 2023 physical abuse investigation was open. The first investigation documented that Sebastian had been the victim of repeated sexual abuse while living in California, that he had reported feeling disgusted with himself over what happened, and that his behavioral deterioration and placement in a special behavioral program at his new school were connected to unresolved trauma symptoms. That Sebastian's therapist had identified sexually aggressive behavior, chronic bathroom accidents as a result of the consequences of the prior sexual abuse, and that Sebastian explicitly feared Proudfoot would physically harm him if Sebastian disclosed. The intake also documented that Proudfoot had already used corporal punishment on Sebastian many times. These facts form a documented foundation of Sebastian's psychological state, his vulnerabilities, and the specific danger he faced in the Proudfoot home. When the 2023 physical abuse investigation opened with allegations against that same stepfather, DCS and law enforcement carried all of this knowledge into that investigation and were on heightened notice that Sebastian's disclosures had to be assessed against everything they already knew about the child and this home. The safety assessment dated March 1st and the FAST 2.0 assessment dated March 5th, 2024, revealed the totality of what DCS knew about Sebastian's situation prior to the disappearance, which included Sebastian had an IEP in Section 504. He was diagnosed with autism spectrum disorder, severe combined type ADHD, 6q27 chromosome deletion syndrome. He was prescribed and was taking Concerta, saw a neurologist at Vanderbilt, and was scheduled to begin ABA therapy at the time of his disappearance. That Sebastian was sexually aggressive per his therapist's report. Per law enforcement, the child had some homicidal thoughts. Law enforcement reported that Proudfoot had been heard by neighbors stating he hated the child and wanted the child to die. Okay, that law enforcement reported that Proudfoot had been heard by the neighbors that he hated the child and wanted the child to die. Per the grandmother, Proudfoot often called Sebastian names and would degrade him. Per the grandmother? Oh, sheesh. That the child was missing and an Amber Alert was issued. That Sebastian had been determined to meet the criteria for participation in the Title IV candidacy program and is at serious or imminent risk of removal from their home. That's interesting. Okay. Sebastian had been determined to meet the criteria for participation in the Title IV E candidacy program and is at serious or imminent risk of removal from their home. Hmm. This determination was made on both cases. First, September 29th, 2022, later updated and no longer meets criteria on May 4th, and then again on March 1st, 2024. That the September 29th, 2022 case included a non custodial placement need. Okay. That the September 29th, 2022 case included a non custodial placement need, indicating DCS recognized Sebastian might need to be placed outside the home. So if they were recognizing this and then they didn't do anything, the candidacy determination is particularly significant. Title 4-E of the Social Security Act provides federal funding for foster care. A child determined to meet this candidacy criteria is one whom the state has formally found to be at a serious or imminent risk of removal from their home. DCS made this finding about Sebastian and then left him in the very home from which it had determined he was at serious risk of being removed. Mm. The combination of the documented sexual history abuse, physical abuse by Chris, admitted by Chris himself, Sebastian's expressed fear of Chris, neighbors reporting that he hated the child and wanted him to die, the grandmother reporting the name calling, so the grandmother reporting name calling and degradation and by Chris, law enforcement reports of homicidal thought. I mean, this is a lot of homicidal thoughts, sexually aggressive behavior, DCS's own formal determination that Sebastian was at imminent risk of removal constituted overwhelming evidence this child was not safe, and DCS ignored it all. Mm. First cause of action: substantive due process, deliberate indifference, and state created danger against all defendants. Plaintiffs incorporate by reference all preceding paragraphs as those set forth herein. The 14th Amendment to the U.S. Constitution provides that no state shall deprive any person of life, liberty, or property without due process of law. In child welfare cases, the applicable standard for substantive, my mouth is dry as shit, due process liability under 42 U.S.C. 1983 is deliberate indifference. That is, whether the state actor knew of and disregarded a substantial risk of harm to the plaintiff, Patel versus Kent. Under the state created danger doctrine, a state actor may be held liable under 1983 when the state's affirmative actions create or increase the danger to an individual. DeShaney versus Winnebago County Department of Social Services. Sebastian, as a missing child with documented disabilities and a known history of abuse, has a liberty interest in his personal security protected by the 14th Amendment. Rogers has a protected liberty interest in the care, custody, and companionship of his son. This claim is brought on behalf of Sebastian through his father and next friend Rogers. The state created danger doctrine requires that the state's own affirmative conduct created or increased plaintiff's exposure to danger. Kennedy versus Ridgefield City. Defendant's affirmative acts that created or increased the danger to Sebastian include knowing his history of SA that had been reported to and investigated by DCS, knowing that Sebastian had a home life that DCS own records showed was marked by physical abuse, emotional degradation, and a stepfather whom neighbors reported hated the child. So they have to repeat all of this, I understand. Tara Hughes. Oh, sheesh. Had to drink some soda there. Hold on. Okay. Hey, did you, they have to repeat it 500 times. I'm not quite sure why they do that, but they have to. Defendants acting under color of state law were deliberately indifferent to Sebastian's disappearance. This deliberate indifference is evidenced by investigating Sebastian's home on allegations of physical abuse by Proudfoot, documenting evidence of abuse and danger, leading to a determination that he was at serious or imminent risk of removal, then closing the case without any action, closing the investigation and thereby preventing any potential intervention or help by other entities, preventing other agencies and individuals from taking protective action by closing their case, ignoring the child's own admissions of living in fear of his stepfather, failing to interview Rogers to obtain any information critical to assessing Sebastian's safety, including Sebastian's expressed fear of Chris's ridicule of Sebastian about his prior SA, and Sebastian's deteriorating mental and behavioral state. The failure to follow up on statements made by the child and school administrators about his abuse, the failure to follow up on statements made by the family's neighbor evidencing abuse and psychological harm, and the failure to deploy resources commensurate with known risk factors. Defendants knew or should have known of the extraordinary risk factors in this case through their participation in the physical abuse investigation, their actual knowledge of Sebastian's prior documented SA and its lasting consequences, and their failure to obtain from Seth critical information about Sebastian's fear of Chris and his deteriorating condition. Their failure to act with urgency in light of these known risks constitute conduct that shocks the conscience. As a direct and proximate result of the defendant's deliberate indifference and affirmative acts creating danger, Sebastian remains a highly at risk missing youth. Plaintiffs are entitled to compensation for the continuing deprivation of Sebastian's liberty and Seth's familial association, punitive damages against the individual defendants for conducting, evidencing reckless or callous indifference to federally protected rights, injunctive relief, directing the DCS to immediately reopen and actively prosecute the investigation with the adequate resources and attorney fees and costs pursuant to 42 USC 1988. Second cause of action. This is to everybody that he's mentioned. DCS sustained involvement with Sebastian through 2023 physical abuse investigation, together with its actual knowledge of Sebastian's SA and its consequences carried forward from 2022 investigation, created a special relationship rise to an affirmative duty to protect him. DCS conducted multiple face to face interviews with Sebastian, entered the family home on multiple occasions, convened multiple agency CPIT reviews, and determined that Sebastian met the 4-E candidacy criteria and exercised significant control over his welfare through its authority to remove him, provide services, or leave him in place. DCS also had an obligation as part of that investigation to interview Seth, Sebastian's other legal parent with joint physical and legal custody, whose knowledge of Sebastian's expressed fears and deteriorating condition was directly relevant to any legitimate safety assessment. Having assumed this protective role and exercised authority over Sebastian's living situation, DCS had an obligation to act with reasonable care to protect him from known dangers. DCS breached this by closing the physical abuse investigation without taking any protective action, despite overwhelming evidence of danger, and by failing to contact or interview Seth to obtain information that would have materially informed a proper safety assessment. Again, against all of the people here, Seth has a constitutionally protected liberty interest in the care, custody, and companionship of his son Sebastian under the 14th Amendment. DCS knew Sebastian identified Seth as a safe parent. Seth told Boswell that he feels safe at his dad's home and identified his father by name and location. DCS documented Seth's contact information and confirmed that he did live in Clarksville. Despite knowing Sebastian felt safe with his father and was being abused in his mother's home, DCS took no steps to facilitate placement with Seth or to alert Seth to the danger faced by his son, or the danger his son faced. DCS deliberate indifference to these facts deprived Rogers of his constitutionally protected interest in his son's welfare and safety. You go on to failure to train and supervise. So there's supervisory liabilities that attach under 42 USC 1983 when a supervisor's failure to train or supervise their subordinates amounts to a deliberate indifference to the rights of the persons those subordinates encounter. So, defendant's conduct violated Sebastian's constitutionally protected liberty. Defendants Walker and Ritchie, as team leader and supervisor, had direct supervisory authority over the investigation. They reviewed the case files, approved the case classification, and authorized case closures. They knew, or should have known, of the documented abuse. Sebastian's fear, the stepfather's admissions, and the 4-E candidacy determination. They failed to ensure that appropriate protective action was taken. The commissioner and other supervisory DOE defendants, or DOE defendants that they have not named yet, established, maintained, ratified policies, customs, and practices that allowed DCS caseworkers to close cases involving children at documented risk of serious harm without taking protective action, adequate follow up, or ensuring appropriate referrals. These policies and practices were a moving force behind the constitutional violations suffered by Sebastian. The need for such training was obvious. DCS investigating the abuse and fears of a disabled minor from a home marked by documented physical and sexual abuse and a household member identified by neighbors as harboring lethal animosity towards the child are placed squarely in a situation where the absence of specialized training in vulnerable victim investigations will predictably result in constitutional harm. The failure to prepare DCS officers for precisely this scenario, the one that DCS had constructive, if not actual, knowledge was likely to arise, given DCS's own participation in their proceedings concerning Sebastian, constitutes deliberate indifference. As a direct and proximate result of the defendant's failure to train and supervise, Sebastian remains a highly at risk missing child, and Rogers has been deprived of his constitutionally protected relationship with his son. Negligence. That's pretty clear what negligence is. They failed to remove him and all of these things. I'm not going to read all of those again because they're very clear. We also have the other lawsuit in just 1 second. Okay. Gross negligence, disregard, same thing. Remains an at-risk child. Plaintiffs are okay. Plaintiffs are entitled to compensatory damages from the governmental entity defendants to the extent permitted by the Tennessee Governmental Tort Liability Act into damages for the individual. So he's suing both them as individuals and as a whole. Intentional infliction of emotional distress. Tennessee recognizes a claim for intentional infliction of emotional distress where the plaintiff can prove 1. The defendant's conduct was intentional or reckless. The conduct was so outrageous that it is not tolerated by civilized society. The conduct resulted in serious mental injury to the plaintiff. Lemon versus Williamson City. Leach versus Taylor. The facts support a finding that defendants' conduct was reckless and intentional. DCS consciously ignored Sebastian's documented abuse, disabilities, vulnerabilities, and the stepfather's documented animosity towards said child and Sebastian's fear of him. Ritchie, Walker, and Quinn, as the final policymakers with direct supervisory authority, made deliberate choices to end the investigation without protective action, to leave Sebastian's biological father in the dark, and to leave a disabled child in a potentially dangerous home. These were not inadvertent omissions, but affirmative choices made with conscious disregard of their effect on Sebastian and Rogers. Their conduct meets and exceeds the outrageous threshold. Pause. I think I would feel that way if it were me, that this is outrageous. I think I would feel that way. Okay. Conduct is beyond what any reasonable person in civilized society should be required to endure. As a direct and proximate result of the defendant's intentional or reckless, outrageous conduct, Rogers has suffered serious mental injury that no reasonable person would be expected to endure. The prolonged, unresolved disappearance of his disabled teenage son, combined with the law enforcement agency responsible for finding that son going completely silent for nearly 2 years. This is not the transient distress of an ordinary grievance. It is a sustained, open ended mental anguish, including the inability to grieve, plan, or act because the whereabout and fate of his child remain unknown, and the agency that could answer the question has chosen silence. This cause of action is asserted against defendants Ritchie, Quinn, and Walker in their individual capacities for their personal, intentional, or reckless, outrageous conduct as described herein. Punitive damages are sought against the individual defendants in their individual capacities. As a direct and proximate result of the defendant's intentional and reckless, outrageous conduct, Rogers has suffered and continues to suffer severe emotional distress, entitling him to compensatory, I hate that word so much, compensatory and punitive damages in amounts to be proven at trial. Prayer for relief. Damages in the amount to be proven at trial, but not less than $15 million. Punitive damages against the individual defendants, injunctive relief requiring DCS to reopen active investigations of Sebastian's case with adequate resources and implement mandatory communication requirements with children's families when their well being is being investigated, attorney fees and costs, pre judgment and post judgment interest, such other and further relief as this court deems equitable. A jury trial is demanded. Service list went to all of these people. Okay, so the other one, yikes, my throat. My throat. This is a lot. How are you guys doing in the chat right now? I know I just got off on a reading. You know, I apologize. I just got off on. Once I get going, that's it. Oof. All right, let's see what you guys have to say. Zoe, no one knows what happened. We absolutely do not know. We know what they showed us on various live streams in a drama community on YouTube. That's pretty much all we know. KP and Seth's discussion about group home type settings made their way to an internet here, so this makes sense. Your throat hurts because you don't read to us enough anymore. Maybe that's why. Take a breather. Yeah, just Samantha, this is a nutty one. It really is. This is a lot, man. I didn't know that those, I don't know. I don't know. I didn't expect that to be coming out. I don't know, Kim. I wonder if they offered him like a victim's advocate. I would assume so, right? Yeah, I just read the monetary figure. Can anybody tell Remy what the monetary figure was? Thank you, Mother McCready. Except that compensatory. It's terrible. I hate that word so much. I did say 15 million plus fees, but yes, I did say $15 million. That's what I said. Yep. Yeah, fuck you, Jen. Never gonna happen. Never gonna happen. All right, let's move to the next one. This is again Sumner County itself. This civil rights action arises from the Sumner County Sheriff's Office deliberate indifference to the disappearance of Sebastian, a 15-year-old child with autism spectrum disorder, severe combined type ADHD, 6q27 chromosome deletion syndrome, who vanished from his mother and stepfather's home in Hendersonville on February 26, 2024. So it's been over 2 years. Am I crazy? We're in July, right? Yeah. So I think they keep meaning to say almost 3, but they've said almost 2. So they're going to need to amend this. But in any case, so this, we already know these things here. We just read all of that. So we're going to go down. Here we go. We're going to start here, okay? Despite all of the context, which was known or readily available to law enforcement through DCS records, the DCS Child Protective Investigative Team proceedings in which Sumner County participated, the detective assigned to the DCS case, the Sumner County investigation into Sebastian's disappearance was inadequate, negligent, and untimely abandoned. Sumner County failed to secure the scene, failed to verify the stepfather's alibi, failed to investigate why surveillance cameras at the home were not working, scaled back the search after approximately 1 week, assigned only a single detective to the case, stopped communicating with Sebastian's father, Seth Rogers, approximately 18 months ago, and has held no press conferences since March 2024. So the jurisdiction, it goes over that, which is self-explanatory. The Sumner County Sheriff's Office is the law enforcement agency organized and existing under the laws of the state of Tennessee, operating within and serving Sumner County, Tennessee. The SCSO is a governmental entity responsible for providing law enforcement services, conducting criminal investigations, and responding to reports of missing persons within its territorial jurisdiction. At all times relevant to this complaint, the SCSO, through its agent, service, and employees and officers acting within the course and scope of their employment, was responsible for investigating the disappearance of Sebastian and was subject to the duties, obligations, and standards imposed by the federal and Tennessee laws governing law enforcement conduct. Here we go with Craddock. Oh boy. Defendant, Sheriff Eric Craddock, is the duly elected Sheriff of Sumner County. He is the final policymaker for the SCSO with respect to law enforcement operations, including the investigation of missing person cases. He is sued in both his official and individual capacity. Defendant Detective Brandon Carter is the sole detective assigned to Sebastian's missing person case. Carter suggested a meeting with Rogers approximately 18 months ago. Rogers agreed to meet the following week. Carter never responded or contacted Rogers again. Carter is sued in both his official and individual capacities. Defendants John and Jane Doe's 1 through 10 are Sumner County Sheriff's Office officers, supervisors, and officials whose identities are presently unknown, but who participated in or had supervisory responsibility over the investigation of Sebastian's disappearance. Plaintiffs will amend this complaint to identify these defendants when their identities are ascertained. Okay. Sebastian was 15 when he disappeared. He was profoundly vulnerable, requiring the highest level of investigative urgency. They go over his disabilities, his IEP plan, requiring his school to provide him with accommodations because he was a student with disabilities. Sebastian was in the behavioral program at his school. He received therapy 3 times per week through Mental Health Cooperative and was on Concerta, saw a neurologist at Vanderbilt, and was scheduled to begin ABA therapy at the time of his disappearance. It's very surprising to me. Pause there. Jace was diagnosed when he was 2 years and 4 months. By 2 years, 8 months, we already had him doing ABA. So it's very surprising to me that they had not had him in ABA therapy. I agree. I totally agree with what you're saying, Hoodies here. This is not about Seth versus Chris and Katie. Seth is stating he was kept in the dark about what was happening with his son. He's saying the agencies did not do their job. 100% agree with that. People won't be able to see past that because of the things that have gone on with Seth and the mentality of many people on here. Hate to say it that way, but it's the truth. People are so loyal to whoever it is that side that they're on that they don't even see Sebastian as a human anymore. They only see what's put in front of them. And that's just the way that it is. I don't understand it. I won't ever understand it, but here we are. All right. His therapist reported that as a consequence of prior SA, Sebastian was sexually aggressive and suffered from frequent bathroom accidents. Law enforcement reported that Sebastian had some homicidal thoughts. It's interesting to me, law enforcement reported that he had homicidal thoughts. How did law enforcement know that Sebastian had such thoughts? I don't know, but before Sebastian disappeared, the Sumner County Sheriff's Office had direct knowledge of and involvement in Sebastian's situation through its participation in the DCS Child Protective Investigative Team. The team included the Sumner County Sheriff's Office, Juvenile Court, Ashley's Place Advocacy Center, the Assistant District Attorney. So, okay, that's how I just answered my own question. Before he disappeared, the sheriff's office knew of Sebastian because DCS had the investigative team, which included the sheriff's office, juvenile court, Ashley's Place Child Advocacy Center, and the DA on November 3rd, 2022, and again in May of 2023. The sheriff's office participated in the proceedings regarding Sebastian's cases, and a detective was assigned through the CPIT. The Very interesting. This is very interesting. So, all right. Through the CPIT proceedings and the DCS records, law enforcement knew or should have known the following. He had been essayed by a peer in California over a period of weeks, which included forced oral and anal penetration. Sebastian was afraid of his stepfather, Chris Proudfoot, and feared being hurt if his father found out about the sexual abuse. Proudfoot admitted to DCS that he whacked Sebastian in the belly. Sebastian's situation through its participation in the DCS Child Protective Investigative Team. Let's see. See. Da, 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 da. Boop. D. Neighbors reported that Proudfoot hated the child and wanted the child to die. Sebastian's grandmother reported the stepfather often called Sebastian names and would degrade him. Sebastian's therapist reported he was sexually aggressive, and law enforcement itself reported he had homicidal thoughts. DCS determined Sebastian was at serious or imminent risk of removal from Chris's home under the Title IV-E candidacy program. Sebastian had multiple diagnosed disabilities, including the autism, ADHD, chromosomal deletion, and he had never left the home alone before. This information was critical context for any investigation into Sebastian's disappearance. It pointed directly at the household as the primary focus of the investigation and at Chris as a person of significant interest. The sheriff's office failure to treat this information with appropriate urgency constitutes deliberate indifference. On February 26, 2024, Sebastian's mother, Katie Proudfoot, reported that Sebastian left the home on his own and his whereabouts were unknown, and that Sebastian has never left the home before. Given Sebastian's neurodivergence, his developmental disabilities, and the documented history of abuse in the home, this report should have triggered the most intensive investigative response possible. On or about February 27, 2024, an Amber Alert was issued by the TBI. The sheriff's office initiated a search that, at the beginning, involved significant resources, including community volunteers and search teams. Pause, my son just texted me something. Me and everyone. Sorry, hold on. This child leaving the house with his phone at 3%. Are you okay? Okay. I love children. You gotta love your kids. That's all. That's the only answer to this whole story. I said, don't use the phone anymore, and he keeps texting. Oh, okay. All right. The initial response was marred by critical failures. The sheriff's office failed to secure the Proudfoot home and allowed reporters and family members, including Seth, to enter the home before it was properly processed as a crime scene. The sheriff's office failed to verify Chris's alibi that he was approximately 3 hours away at the time of Sebastian's disappearance. Additionally, The sheriff's office failed to investigate why surveillance cameras at the Proudfoot home were reportedly not working on the day of Sebastian's disappearance. The fact that the cameras were offline and that there was no investigation as to why and when the cameras were not functioning should have been a significant cause of suspicion and point of thorough investigation, because upon information and belief, Katie Proudfoot installs and operates security cameras for a living. After approximately 1 week, the sheriff's office scaled back its physical search for Sebastian and shifted to what it characterized as the investigative side. Only one detective, Carter, was assigned to the case. The sheriff's office held a singular press conference April 3rd, 2024. No public updates were provided, no reward was offered, no additional resources were deployed. Law enforcement stopped searching for Sebastian. Rogers attempted to stay in contact with Carter and to provide information from the public, including tips he received through his own outreach efforts. Carter failed to follow up on tips that Rogers provided. One such important tip, upon information and belief, was not pursued, came from one of the nurses that cared for Sebastian at his doctor's office. Upon information and belief, this nurse reported that on Friday, February 23rd, 2022, Katie preemptively canceled Sebastian's doctor's appointment scheduled for the following week, just a day or so after his disappearance. The nurse stated this was uncommon and, in hindsight, concerning, as Sebastian was always present for his appointments, which were frequent and ongoing. So, on Friday, February 23rd, Katie canceled the doctor's appointment that was scheduled for a day or so after he had disappeared. Okay. Approximately 18 months before the date of this complaint, Carter suggested meeting with Rogers. Rogers agreed, and the proposed meeting was the following week. Carter never responded. No further communication from the sheriff's office has been received by Rogers. The TBI also told Rogers they would call back, but never did. This 18-month communication blackout, during which a disabled child remained missing and unaccounted for, is itself evidence of deliberate indifference. Sebastian's case was not allocated the resources or attention it deserved. Sebastian was assigned one detective. Law enforcement held a single press conference. They made no request for FBI involvement, deployed no advanced forensics. Worse yet, law enforcement refused to accept leads from the public, much less follow up on them. And they completely abandoned all communication with Sebastian's father. Tennessee ranks 70th? No. 7th nationally in missing persons cases. These words are all going together now. They rank 7th nationally in missing persons cases with 991 active cases as of mid 2025, 924 unresolved cases in the NamUs database as of January 2025. The Sumner County's failures are not isolated, but reflect systemic deficiencies in how Tennessee law enforcement handles missing person cases. Well, I don't know that I can disagree there. Plaintiffs incorporate by reference all preceding paragraphs as those set forth herein. The 14th Amendment of the U.S. Constitution provides that no state shall deprive any person of their life, liberty, or property without due process. In child welfare cases, the applicable standard for substantive due process liability under 42 U.S.C. 1983 is deliberate indifference. That is, whether the state actor knew of and disregarded a substantial risk of serious harm to the plaintiff. Patel versus Kent. Under the state-created danger doctrine, a state actor may be held liable under 1983 when the state's affirmative actions create or increase the danger to an individual. DeShaney versus Winnebago County Department of Social Services. Okay, these are things that we've already read under the 14th Amendment. Okay, we also cited Kennedy versus Ridgefield in the other one. So rewind if you didn't hear that. Okay. Okay. These are all the same. Just make sure what's different and what is the same, because I would assume much of these would be the same. Defendants knew or should have known through these proceedings, DCS records. Okay. Second cause of action. Boop. Sorry. Pursuant to the U.S. Supreme Court decision, Monell versus the Department of Social Services, a plaintiff can hold municipal or local government entities liable for constitutional violations caused by its policies, customs, or practices. Upon information and belief, Sumner County, through SCSO, maintained official policies, customs, and practices that were the moving force behind the constitutional violations, including a custom of under-resourcing missing persons investigations, a policy or practice of failing to maintain communication with families of missing persons, a custom of failing to coordinate with DCS and other agencies regarding known risk factors, and a practice of effectively abandoning investigations without resolutions. These policies and customs reflect deliberate choices by Sumner County's final policymaker, Defendant Craddock, regarding the allegations of the investigative resources, the prioritization of missing persons cases, the scale of the search, the assignment of personnel, and the cessation of family communication. They are attributable to Sumner County as official policies. Sumner County policies, customs, and practices were the moving force behind the constitutional violations described herein. And Sebastian remains missing. Let's see. They go on to say how they are entitled to compensation. Okay. Failure to train and supervise. Okay. Supervisory liability attaches under 42 U.S.C. 1983 when a supervisor's failure to train or supervise subordinates amounts to deliberate indifference to the rights of persons those subordinates encounter. The inadequacy in training must be closely related to and the actual cause of the ultimate constitutional injury. Okay, so basically he's saying, look, Craddock, you didn't train your officers and detectives to do any of the right things, and this whole case was done wrong. Upon information and belief, Craddock failed to provide officers and detectives with adequate training in the investigation of missing persons cases involving disabled and neurodivergent children, the assessment and prioritization of cases presenting known abuse risk factors, including prior DCS involvement, the identification and preservation of crime scenes in the context of missing children investigations, the proper verification of alibi information from individuals in the missing child's household, coordination with other agencies including DCS, the TBI, the FBI, in cases involving high-risk missing children, the deployment and maintenance of investigative resources sufficient for the duration of an unresolved missing persons case, and maintaining required communication with the families of missing persons throughout the investigation. The need for such training was obvious. Law enforcement officers investigating the disappearance of a disabled minor from a home marked by physical and sexual abuse, active DCS involvement, and a household member identified by neighbors as harboring lethal animosity towards the child are placed squarely in a situation where the absence of specialized training in vulnerable victim investigations will predictably result in constitutional harm. The failure to prepare officers for precisely this scenario, one that the sheriff's office had constructive, if not actual, knowledge was likely to arise, given Sumner County's own participation in the CPIT proceeding concerning Sebastian, constitutes deliberate indifference. All right. Whew. Right now, if you are so far agreeing with what Seth is saying, put a 1 in the chat. If you are disagreeing with what he's saying, put a 2 in the chat. Kiwi 1.5. Of course, Kiwi. So most people are agreeing with Seth's sentiments right now. Oh, we have another 1.5. Petty, blissful. I'm not saying he's bad. I'm just saying he got her people off. He got her people off? Oh, is she talking about one of the cases that the lawyer heard? I'll wait on facts, ma'am. This is all the facts we're going to get right now. It's not agree or disagree. Some of it I know isn't factual. Well, I mean, I don't know that we know what's factual. Well, I don't know. I don't know. 3 undetermined, 3 undetermined. It's too complex to say. I'm waiting. Got bad. Sorry, typo. Just because Seth says it's true doesn't mean it is. No, of course not. Here's the thing, though. So you can file a lawsuit. You can say anything in a lawsuit, of course. When you go into court, you are going to have to prove what you have, what you're saying, right? Additionally, there'll be exhibits, there's going to be witnesses, cross examinations, there'll be discovery, there's going to be all kinds of stuff that you're going to have to bring with you to ensure that all of this comes out in the wash here. I'm looking to see if there's anything else that is connected to these. I'm not sure. Hold on here. It's page 2. No, this is just something else there. Let me see. Business disclosure. No, nothing. Okay. All right. Let's keep reading. All right. So, as the final policymaker, same thing. Had they been trained, maybe we wouldn't be in this mess, basically, is what he's saying. Had you trained them properly, we probably wouldn't be here right now. Allegedly. Okay. 4th, the cause of action, violation of Tennessee victims' rights against all defendants. In Tennessee Constitution, the Tennessee Victims' Rights Statute guarantees crime victims and their family the right to be informed about the status of the investigations and to be treated with dignity and respect. The defendants violated Seth's rights under these provisions in the following specific respects: failing to treat him with dignity and respect by abandoning all communication for approximately 18 months, failing to supply him with information and updates regarding the investigation as required by TCA 4038-103, failing to inform him of the investigation status, investigation developments, or the identity of personnel responsible for the investigation in violation with 4038-107 and 113. Failing to respond to Rogers' attempts to provide investigative tips and leads, effectively excluding him from participation in the effort to locate his son, failing to hold any public communications regarding the investigation after April 2024, leaving Rogers and the public without any information about Sebastian's case for more than 2 years. As a direct result of these violations, Seth has been denied information critical to his son's safety and well being and has been excluded from the investigative process to which he is entitled by constitutional and statutory right, and has suffered severe and ongoing emotional distress from the enforced ignorance of whether his son is alive or dead. I just hate that line right there. Gray Hughes, thank you, sir. It's a lot of reading. I could have had AI read it, but there's really no emotion there. Thank you so much. I appreciate that, Gray. All right. Okay. Fifth cause of action. Same thing against everybody. Okay. The failures alleged herein are not policy level discretionary choices, but operational breakdowns in the execution of an investigation that was already underway. Failing to secure a scene, failing to verify an alibi, failing to follow up on tips, and failing to maintain communication with the victim's family are ministerial, sure, operational acts and not protected discretionary functions. Once they undertook the investigation of Sebastian's disappearance, it assumed a duty of reasonable care in conducting the investigation. Tennessee courts recognize that a duty of care arises when the defendant's conduct creates a foreseeable risk of harm to an identifiable plaintiff. The sheriff's office had direct, documented knowledge of Sebastian's profound vulnerabilities, his disabilities, and the known danger in the Proudfoot household. A reasonably competent law enforcement agency, knowing what the Sumner County Sheriff's Office knew, would have preserved the crime scene, verified Chris's alibi independently, investigated the non functioning surveillance cameras, deployed resources commensurate with risk, maintained interagency coordination with the TBI and FBI, and sustained regular communication with Sebastian's father throughout this investigation. And they did none of these things. Craddock and Carter's negligent acts and omissions amount to willful, malicious, and grossly negligent conduct. Okay, they breach their duty through acts and omissions. All right, let's see. Ongoing harm under the Tennessee Governmental Tort Liability Act. He mentioned that earlier. Intentional infliction of emotional distress. Now, you got to keep in mind, too, a jury might be hearing this. If a jury's hearing this and they're not super aware of this case, I don't know. I don't know. The facts support a finding that defendant's conduct was reckless and intentional. Carter consciously ignored Rogers' agreed upon meeting and then never contacted him again. That would make me crazy. I would definitely be knocking on that damn door for sure. Like, excuse me, sir. Why are you doing that? Why are you doing that face there? May I ask? This is his father. I mean, I don't understand. That's his dad. Thank you so much. Nope, not today. I appreciate you. Yeah, people are very skewed, and it's alarming, I would say. So if he had him, let's say every weekend or every other weekend, in addition to weeks at a time in the summer. Now you have to remember too, they moved there in 2020. So that's when the divorce was. He went missing in 2024. So this arrangement was happening in Tennessee. In California, I don't know exactly what their visitation and all of that was, if he was more involved, less involved. I don't know. When Katie and Chris first come out and were talking, they had no issues with Seth. Seth had no issues with them. Seth's first interviews, I watched them all today. He was saying, I listened to them. He was saying that most of his communication went through Chris, that he and Chris got along, and most of the communication was going through him. That they were talking about doing a I actually have it right here. I can actually play it for you. Exactly what I clipped earlier because I didn't know that I was going to have this. So I just planned on putting together a video until this came out. The woman who calls herself Bullhorn Betty. That's a different one under Sebastian. Okay, Bullhorn Betty. Let me see. That's not it. It is. That was about her lawsuit, actually. Bullhorn Betty. We'll get you another time, lady. This one is. Was it? I think it was this one here. Hold on. Let me share this with you guys really quickly.
Were there any indication in your communications with Katie?
Tracy, you're a great YouTuber.
The custody arrangement, it seems you both have custody and he'll spend time with you as well as with his mom. Were there any indication in your communications with Katie that like she didn't want custody, that she didn't want that responsibility, and there were problems and she was running into some rough waters? Anything like that?
Most of my discussions were actually taken care with Chris. And he was Sebastian.
This is absolutely not true. Hold on, please. This is not true. You've been fed this. Okay. His weekends were for Sebastian. There were a couple of times where he had to work and Sebastian was there. People keep saying that because of the idiotic things that he's done and getting himself involved in this damn RICO and all of these things. But there's so much misinformation and crazy stuff that people kind of just run with forever. And it's so damn much. It's a lot. I mean, it's just too much sometimes.
He was supposed to come live with me. Chris was working on Katie, on getting her to agree to it. And all I wanted was my son to come live with me.
Katie said he was a good dad.
I've already got him enrolled in school. I've had him enrolled in school. I gotta find him.
I mean, we may not like Seth. That's fine. We don't have to. What we're not going to do, what this channel isn't going to fucking do, is drag this guy while his son's still missing. I did participate in that for a little bit because I was shocked that he was putting this information out there. Now that I am reading this, thank you so much, Connie. I appreciate you. Thank you. Now that we're reading this and we're seeing that this has been put into a lawsuit, thank you so much, Body. Yes, there was one where he said Sebastian was outside waiting for him with his coffee. That was said. People ran with that. It was a lot. It was a lot. Okay. Seth has made mistakes. None of us are fucking perfect. And I'm not talking about the RICO. The RICO is the RICO. You know, that's very unfortunate. I think he was sold a pipe dream there. I don't know. I don't know what he expected from the internet or what he thought was going to happen, but it turned out to be a damn mess, is what we ended up getting. But he was putting this stuff out there without actually telling everything that he could tell, and now it's in the lawsuit. So we're seeing this. So there are DCS records clearly that were attached, right? We probably aren't going to get to directly read those, but there was also, yeah, did you see how many people were involved? This wasn't some small thing here. Let's be really, really clear on what we're reading here. Okay? Let's be super fucking clear on what we're reading right now. He's not making this up. This is not made up right here. Before Sebastian disappeared, Sumner County had direct knowledge of and involvement in Sebastian's situation through its participation in the DCS Child Protective Investigative Team. That included Sumner County Juvenile Court, Ashley's Place Child Advocacy Center, and the Assistant District Attorney Jenny Smith. Whatever it was that was going on, him and Chris were talking about it. Maybe Katie wasn't ready to let go of her baby. Okay? Maybe she wasn't. Maybe there was tension between Chris and Sebastian. Sure. Sebastian's becoming a young man. There were a lot of things going on. As we're seeing and reading these things, his grandmother, his therapist, the police, you have the courts involved, an advocacy center, the fucking district attorney. Something was happening here. We don't know what it was, but something happened. We don't know what. Be careful constantly judging other people based on what you are sold. And there's so much fucking selling that goes on around here. Have some empathy. What kind of father was he who only had him 2 times a month? Shut up. Please. Just stop. We're on the 4th cause of action. I hate to stop and take away from what we're talking about to address those things, but gosh, you see it so much around here. Just so much. People don't think, they don't read, they don't use critical thinking. They just go with whatever their favorite creator tells them, and they just fucking believe it. And it's like little baby parrots are everywhere. It's exhausting. Anyway, let's move on. As a direct result of defendant's violations, this is where we were. So the 5th, negligence and gross negligence. Same things. They're going over the same situations here. There's a lot of causes of actions against them, it seems. And I would be beside myself if my child went missing and nobody would communicate with me. I don't care if I'm the biggest asshole who ever walked on this planet. It's my child. Clearly, you could verify I was at the jail where I work, so it wasn't me. Why aren't you communicating with me? I couldn't do it. I would be beside myself. Well, an investigation was done, sure, but an investigation for how long? Do you think a week is fair? Is Sumner County so busy that they, you know, can't be out there searching, that we don't have search teams going? I mean, I don't know. I'd be losing it too. I would be out of my mind. Out of my mind. And you can say, oh, well, I dealt with parents like him. Does that mean he's not entitled to communication? Does that mean he loved his son any less? I don't think so. I don't think so. I mean, why not walk away? Why not be quiet like everybody else? Why not say another word? Why not say, oh, well, I only fucking saw him 4 days a month. What do I care? If that's how we really thought, then, well, we only know what's verifiable, right? One press conference, the community had some prayer vigils. There's one detective assigned to the case. These are the things he's alleging. We don't know for sure what they've done. Without a shadow of a doubt, we don't know. And they could walk into court with, tons and tons and tons of people that they've interviewed and talked to and verified and all of that. So, his stepdad, Helen, his stepdad. No, but they don't have to communicate with him about the investigation. For all we know, they may suspect him. I mean, sure, except he hasn't been interrogated. He hasn't been, you know, I mean, I don't know if they suspect him. I have no idea. They keep saying they feel like he just, from my understanding, they haven't really said much. They've kept this close to the vest too, just like they do a lot of these things. All right, intentional infliction of emotional distress. Very similar to the last one. Same thing. Negligent infliction of emotional distress. By affirmatively undertaking the investigation and establishing a relationship with Seth as a key family contact and source of investigative leads, the Sumner County Sheriff's Office occupied a position of control over information critical to Seth's well being and was in the best position to prevent the emotional harm described herein. They breached this duty through the acts and omissions described herein, which constituted gross negligence and conscientious disregard for Sebastian's safety and Rogers' rights as a parent. Okay. Emotional injury meets the serious or severe standard required under the Tennessee law. Rogers has endured more than 2 years of unresolved certainty about whether or not his disabled son is alive or dead, compounded by the knowledge that the agency with exclusive authority to investigate Sebastian's disappearance has gone silent. Um, Plaintiffs will support the serious of Rogers' emotional injury with expert medical or scientific proof, including testimony from qualified healthcare providers who evaluated Seth and can opine that his injury is serious or severe and consistent with the negligent conduct alleged. So clearly, he's been seeing a therapist. This cause of action is brought against all the defendants. The negligent failures to communicate and to add conduct to a reasonable investigation are operational, not discretionary. Acts failing with exceptional, okay. Prayer for relief, same thing, $10 million. Attorney's fees. So this one's 10 million, the other one's 15 million. I mean, it says, but not less than. So a minimum of 25,000. 25,000. A minimum of 25 million is what he's asking for. He is demanding a jury trial, and all the things have been sent to all the people. And there you go. Yeah, he didn't know any of this. Let me read this. Chasing, riddle me this, though. If everything he's saying is true, let's assume it is. He knew all of this. No, he didn't know. He knew about California. CPS was involved there, right? Or they did an investigation in California. It's when he lived with Katie. Then they move here. He reports it to somebody at school. They get all of these people involved here. This one. And he wasn't told until, I don't know at what point. We know that he knew about the sexual abuse in California and that there was something done in California. Now, I think that there were two different stories too. Didn't we hear that the boy was Sebastian was like 8 or 10, the boy was like 15. Then we heard that he was maybe 8 and the boy was 13. I don't know. Let me view the summary on this. Yeah, he didn't know all of this, unfortunately. And you can't just take your son either, especially when you've got a custody agreement. So he was talking to Chris, trying to get Chris to work out with Katie that they would be able to switch. Um, they had equal custody, but the physical part was different. So they were trying to switch that so that he could get him enrolled over there where he lives. It's about 45 minutes to an hour away, enrolled in the right school and set up his other things that he would need. So he was trying to do that while Chris was speaking to Katie about agreeing to it. And she didn't agree to it. Um, so wait, didn't Seth have abuse claims against Sebastian as well? We were told we didn't understand what it was like. We were told we didn't know what it was like. I know that they came to the house and there was the gun situation. Remember, the gun was in the desk in California? And that he told them, my dad said he's going to beat me or something. Remember that one? And he was like, oh, I'll show you what beat is, or I'll show you whatever it is, you know, I'll show you what it is. And he showed him the video game of like Mortal Kombat, like, ah, psh, psh, psh. Yes. And that really is the issue, right? We can say Katie had a CPS case, Chris had a CPS case, Seth had a CPS case. The point is, due to the sexual abuse that he endured, he had some physical issues as well as some behavioral issues. Those did happen while they were in California, while he was living with Katie. Those things happened. So his therapy, people at school, and all those other people ended up knowing about this, and there was a concern. But, you know, what is he going to do? What is Sebastian going to do? Say, take me out of my house? No. I mean, and also, too, when a kid has a disability and there are things going on, we don't know what the true relationship with Chris and Seth really were. I mean, Chris and Sebastian. Maybe he didn't want to say anything else. Maybe he did not want to go down that road. He didn't want to cause problems. Who knows? He was already maybe in his mind causing enough problems because of the pull-ups and the sexual aggression and the ADHD and taking medication. It's a lot. That's a lot on a kid's shoulders. There's so many things, it's just so much. I just can't imagine dealing, you're a kid and you're dealing with all of this stuff. And then you've got these disabilities and you have other thoughts roaming in your head. They said he had homicidal thoughts. I mean, it's a lot. It's a lot. I don't know. And I don't think we're taking all of that into consideration. Sometimes I don't think we do. I just think we look at who we like better, I think that's a lot of it. Like, oh, look, that sucks. Does that matter when it comes to the facts of the case? If he can prove the facts of the case, he wins. That's really it. That's not Katie versus Seth. It's not. It's not one versus the other. We don't know. They could have sent him letters, sure. They could have. They could have made a courtesy call and he missed it. They could have, whatever. They could have whatever. I don't know. Yeah, and afraid. You don't want to cause more issues, and you don't want the issue to be you, you know? You don't want that. And I don't know what happened with membership. Maybe somebody did, but I just see somebody saying, "Oh, I got a membership. Thank you." I can't see it on this end. So if that did happen, thank you. Um, Seth had to get a lawyer for the records. Yes. Why would he even want him? You know, if he's this like trash guy who just doesn't care, you know, I don't know. I don't know, man. I don't know. If Seth didn't know, then why would he even think to look into the doctors and the CPS? Have you read all this, Laura? Here's the thing. They were working on trying to figure all of this out. There were, oh, thank you so much, Pickles. There were conversations had between the family. Chris and Seth were having convos about him maybe coming to live with him because of his behavioral issues. I think he was clear. He knew about those. What I'm saying is, you know, they closed these cases and didn't communicate anything with Seth, and one was very quickly, right, like not that long before he disappeared. I don't know. There's a lot to it. It appears. I mean, how long have we been reading? Ugh, 2 hours. So there's 2 hours of it. Um, yeah. Yep. Whew. Let's see here. Let me see something. Let me see one thing here. Let me see if there's a better way to do this part of it. Hold on, guys. Ah, I did not mean to bring you guys over here with me. Hold on. Give me 1 second. I don't want that. I want this. Let me mute because you guys are going to hear me type like crazy. All right, so I just had to type really fast. Let's see what happens here. During the 2023 physical abuse investigation, DCS never notified Rogers that an investigation into the stepdad was underway, nor did they interview him to obtain observations, leaving him in the dark. Regarding the danger faced, despite documenting that the child felt safe with his father and faced severe risks. Okay, so he became aware of the agency's failures following his son's disappearance on February 26, 2024. Okay. Let me see something. Oh, all right. The lawsuit notes DCS own records established that it knew this child was in danger. There was a There were details March 1st, 2024. Okay, so he went missing February 26th, 2024. DCS and this FAST 2.0 assessment was done, which uncovered systematic failures. At that time, things were brought to light. So let me look at this FAST 2.0 assessment. Let's look it up right here. All right. The Family Advocacy and Support Tool in Tennessee. FAST Tennessee. Let me see. Like, I'm wondering why they did this after he went missing, but I don't know. All right. Here's what I'm reading, okay? This is what I'm seeing. The FAST 2.0 assessment in Tennessee is a crucial tool for evaluating child safety, especially in cases where a child goes missing. This assessment focuses on understanding the family dynamics, identifying risks, and determining proactive factors that may have influenced the child's safety and well-being. They do a comprehensive evaluation. They assess the entire family unit, including all children, caregivers, to gather a holistic view of the entire situation. Risk identification helps in identifying specific risks that may contribute to the child going missing, such as an unstable family or previous incidents. The tool is designed to facilitate communication among all service providers, ensuring that all parties are aware of the family's needs and strengths. FAST is noted for being easy to understand and implement, making it accessible for families and service providers alike. Okay, so that makes a lot more sense, right? Does that make more sense to you guys now? That this here was done. Let me open this back up here. Let's go back to share this, right? So we're going to close that and we're going to look for FAST. All right. So it's mentioned 3 times. All right. A DCS safety assessment was initiated March 1st, 2024 and completed March 5th. As of that date, he had been, well, as of this date, they say he had been missing for nearly 2 years, but it's nearly 3 years. It's not 2 years, right? We determined that earlier because he went missing February 2024, correct? Here we go. February 26, 2024. He went missing, right? Oh, I did not mean to do that. I hate when it does crazy things like this. Whoop. Oh, you fucker. Hold on. All right, I don't want to do any of that. Where's the undo button on this bitch? Okay, we're just gonna go to the other one because that's broken. I've now broken that one. All right, so let me close that. Boop. All right, we're going to go back here. And we're going to look for the word FAST. Okay. Safety assessment was initiated March 1st. A FAST 2.0 assessment was completed March 5th. So once that was completed, here we go, right here. The safety assessment dated March 1st and the FAST 2.0 assessment dated March 5th revealed the totality of what DCS knew about Sebastian's situation prior to his disappearance. Now, remember when he was on with, I've got it right here, actually. I did download that, didn't I, today? Sebastian, and it is, the hell's his name? Nope, this isn't him. This is the other guy. That's not the same dude. Hold on 1 second here. I can tell you exactly. Hold on. What the fuck was his name? His name is Justin. I'll tell you. Hold on. Bum bum. Justin on TikTok is not his name anymore. Actually, his name is Just in the Nick of Time. So we're going to do Just in the Nick of Crime. Okay. Seth Rogers. And it was in the very, 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 very beginning. 2 years ago. Interview with. Perfect. Thank you, sir. Thank you, sir. This is exactly where I left off. All right, hold on. This is the very beginning, back in the very, very start of all of this. Let's look at it, okay? And we're going to look at the transcript, or we're going to look at the ask function here. And I'm going to share this with you guys. Hold on. Share screen. All right. This is what I was looking at earlier today. And we're going to go. I watched a little bit of it, so we're going to ask, when is innocence mentioned? 3628. So here we go.
This kid took my son's innocence, and he molested him.
So you take your time.
And there was nothing I could do in California because the kid was 13. But they let that happen. And they didn't bother to try to even get my son help until last year. Here, my son is just turned 15 in December. That means he's been dealing with an emotional, stressful, traumatic incident for the last 7 years. And I've been trying to help him. I've been trying to get him help. Finally, CPS never contacted me. One day I went by there just out of the whim. It was the last day they were closing the case. And they informed me they've been trying to get a hold of me for the whole time. And I was like, well, my number hasn't changed in years, like 12. And they're like, well, nobody had your information. And I was like, well, his mother did. And she didn't even bother to give him that. They turned around and they were like, well, we can't find any evidence of any abuse. And so they submitted that to the court. The court dismissed everything.
So one thing, hold on, let me try to get this better so we're even size. There we go. One thing that I want to say to the people with this is, oftentimes you want to make sure that you believe victims 98% of the time when they accuse somebody of something, but there are situations where you can tell that things aren't truthful. I will tell you that I have talked to Seth at length about some of this stuff, and I truly, and I would say this even if he wasn't here, believe him, because I think there's a couple reasons why. So you can tell the way.
So I put that in the chat. Today, what I did while I was working is listened to, I can tell you, I've listened to 1, 2, 3, 4, 5, 6, 7 videos regarding Sebastian. And I'm talking about like the way back, very, very beginning of the videos. Just to get an idea, like, well, what was he talking about in the beginning? What was going on here? What was happening then? And it really, it was kind of making more sense because I hadn't seen these documents just yet. So, Sally, I do agree with that. And now, why? Do we know why? We don't know why. Katie could have had a great reason. Maybe she had the flu, you know. Maybe she had a nail in her foot. Fucking, I don't know. Maybe their dog was sick. I have no idea. Of course, it's strange, and people are going to think that it's very weird. And I understand, you know. Sometimes things are just a coincidence, though. It could be just a coincidence. I don't know. I don't know. I understand him staying out of town. Yeah. I mean, that makes sense. You don't want to go back and forth, but who knows? But I'm going to end this here. It's been 2 hours and 10 minutes. And for people to want to watch this, they're going to be like, this is way too long. But I did my best. I know some of the words were mispronounced. I do apologize about that. And the dry mouth is gross. So, sorry. At school and through, he was about to go to ABA. But he was in therapy 3 times a week. Yes. You got to remember his therapy. I mean, so you've got autism, ADHD, some aggression, some behavioral issues, some trauma from the sexual abuse. So the therapy may have been all encompassing. It could have been, more of an ABA type of therapy, and they were switching him to ABA. We don't know. But he knew that he was in therapy, of course. Yeah. Thank you guys so much. I'll probably be on tomorrow at some point and we can chit chat. All right. I love you. Thank you so much. Good night.